The preamble of the Constitution makes one feel, when one reads it, the heartbeat of the great organic document. It encapsulates the characteristics of the aspirations of the people and sets out the ideals of identifying the nature of the state the Constitution intends to have, and further epitomizes the fundamental philosophy of an egalitarian society and a progressive state. The words of the preamble, and I mean it, are simultaneously metaphysical and practical, and lay down the objectives upon which of this country was laid. The work so later being on the spirit of the Constitution. It's a delightful one to quote a single line from 𝐂𝐿 what is said about the preamble. Preamble is the horoscope of our sovereign democratic republic. Look at this sentence, how eloquent and voluminous it is. The preamble has been called the soul of the Constitution because every particular detail and the fundamental principles get the instinct of verbalization when the other ideas are read in harmony with the preamble. Preamble converts every article into a very active verb. That is why it's called a great declaration. Preamble acts as the key to understanding of the Constitution and makes us understand what the founding fathers had meant when they had drafted this grand document. It must be stated with profit that the preamble was incorporated after all the articles were drafted, and that too after a keen and interesting debate. And that is why every word used in the preamble is absolutely precious. I feel the preamble has a structural rhythm. It tells us the source of the authority of the Constitution. It speaks about the nature of the is being established. It defines which the polity is intended to achieve and sets out the goals which the nation intended to have. These are the basic four objectives. The preamble, as it now stands, defines India as a sovereign, socialist, secular, democratic republic, committed to all citizens justice, liberty, and equality, and fraternity. With each of these terms as specifying the realm in which its virtues must operate in the nation, that the people of India, the right they are giving to themselves. Justice is in the sphere of social, economic, and political. Liberty is ensured in the realm of thought, expression, belief, faith, and worship. Equality assured when it comes to the sphere of status and opportunity, and thereby creating fraternity, which will promote the dignity of the individual and the unity and integrity of the country. That's India. One thing I would like to add about fraternity. Fraternity lays emphasis on the dignity of the individual. I am not speaking elaborately about the dignity of the individual, but I am trying to convey it to the younger generation that the dignity of an individual has its roots in the preamble, apart from other fundamental rights which crystallize. As I read the preamble from time to time, I find they have the potentiality to enthuse, kinetically inspire every generation. True it is, the preamble states the time, but it is not dated. It is not static. It encapsulates and incorporates the generational spirit, for it always remains in the indestructible present. To explicate, the we the people is not a time bound concept, but it is a representative concept of the constant present. It included the past and includes the present, and it shall include the future. Having said this all about the preamble, let's have a look at certain precedents and try to understand how the judges have understood or what kind of theories can emerge from their understanding. In Peshikaka case, in the year 1955, after after referring to the preamble, the basic features, the nature, and the court said it is protects the individual and it is also meant for public policy. So I would like to call in this judgment the judges understood the preamble in the backdrop of public policy theory or constitutional policy theory. That is how the preamble was understood, and according to me, the right perspective. In 1957, there was a presidential reference which formed the subject matter of Federal Education Bill. The Constitution bench was dealing with the constitutionality, the possibility of being challenged ever the president had referred. The court said court was dealing with education. The court said the inspiring and notably expressed preamble, mark the words, the inspiring and notably expressed words of the preamble records the solemn resolve of the people of India. Nothing provokes and stimulates thought and expression in people more than education. I would like to call it theory of resolve. Theory of resolve. The Constitution bench leans on this theory and accentuates it that such resolution, such understanding can be better understood if people are educated. That is how the court progressed. Then came a quite a different situation. In the year 1960, in Beruberi Union case, the court said the preamble is not a part of the Constitution. I want the students to understand this history. The court said it's not a part of the Constitution. The language used, they refer to the words of Story, who had said, a key to open the mind of the makers. It's meant for the general purposes, but doesn't confer anything else, and it cannot be regarded as a part of the Constitution. So, I would like to call this theory or call this doctrine a general purpose doctrine. So, the nine-judge bench propounded that it has to be read for general purpose. It is not a part of the Constitution. This judgment continued for some almost more than a decade. In 1973 came the locus classicus, case one on the Bharti case. Case one on the Bharti, the court said, I'm not saying who said what. Basically, it has been said the constitution makers, the preamble, the pride of place. Now they put it on a pedestal and they developed it. They said the constant strain which runs throughout each and every article of the Constitution is reflected in the preamble, which could and can be made sacrosanct. You will find from this judgment the court developed a constant thread doctrine or a constant thread theory and said pride of place and added sacrosanctity to the preamble. These are the two developments. With the passage of time, ideas change, things get added. Correspondent Bharati Adam today, and I'm sure in times to come, shall maintain its status as a locus classicus. But let's see and appreciate what the court says in Indira Nehru Gandhi case. They are moving in a conceptual realm. The court says The essential features of the great concepts set out in preamble are delineated in the various sections of this article, and these specific provisions enacted in the Constitution can alone determine the basic structure. If we really scrutinize in a proper way, you will find the court is delineating the theory of essential features and the basic structure doctrine. They say the basic structure doctrine has to come from the articles. That's the law. But they say the essential features are the great concepts which are delineated in various provisions of the Constitution. It can safely be said they really lay down the essential feature theory. They quoted 𝐂𝐿𝐥𝐿𝐄𝐂𝐑𝐈𝐁𝐄, the illustrious author on the constitutional law of India, who says the preamble moved the hearts of men to stir them into action. 𝐂𝐿𝐥𝐿𝐄𝐂𝐑𝐈𝐁 says what I have already said in the beginning. They verbalize, they activate the activities of a citizen. The framers of the legislation, the lawmakers, the policy makers. The nouns get transformed, the nouns get metamorphosed into verbs. This essential feature theory gets further developed to crystallization of concept theory into Minerva males. They get into concept theory. Now, question arises before the Supreme Court with regard to judicial review of declaration of emergency under Article 356(1) of the Constitution. The court, referring to the Constitution, states, to the preamble of the Constitution, states, the preamble of the Constitution is an integral part of the Constitution. Now this integral concept comes in, the integrality comes in. Democratic form of government, federal structure, unity and integrity of the nation, secularism, socialism, social justice, judicial review are basic features of the Constitution. My entire purpose of reading this passage was that with Boehmite case, we were dealing with the power of judicial review in the context of proclamation of emergency. The preambles is interpreted through the aid of theory of integral facet. Early 90s, some of you might have witnessed, I'm talking about the senior persons, the reservation, the Honb'le Commission case in Rasani. It has been said that the fourfold objectives of securing to its citizen are justice, liberty, equality, and fraternity. And they display the statesmanship of the highest order. And, in other words, the preamble to the Constitution are the sentiments, and it is the key to the minds of the framers of the Constitution. And they go by the goal theory, purpose, discernment of desire. I quote the decision, one line. The goal enumerated in the preamble of the Constitution of fraternity, assuring the dignity of the individual and the unity and integrity of the nation, must therefore remain unattainable so long as the equality of opportunity is not ensured to all. Equality of opportunity is conceived from the purposes, from the design set out in the preamble. The achievement theory is a kinetic process, and therefore I would like to call it this postulate the kinetic process theory. In the said judgment, for the first time, in clear cut words, the court pronounces the, the preamble, the basic feature of the Constitution, therefore promises equal opportunity and status and dignity to every citizen, in actuality of which has been ensured by empowering the state to take positive steps under Articles 15.4 and 16.4 of the Constitution. This is the theory of introduction of the basic structure, conferring the status of basic structure in absolute, unequivocal terms in this judgment. So you will find the conceptual framework, how it has evolved. Now, I will go to my second limb of explanation. The preamble has many key words. I do not intend to explain word by word, though each word is a precious one. Combined, it's a jewel in the crown. Segregated, each is a invaluable pearl, a priceless diamond. Let's understand first what is meant by sovereign. When you talk about sovereign, we are not being guided by the political theory of state, the territory, and all those kind of things. We are trying to understand what the preamble is going to set out for the constitutional provisions to follow. Sovereign is meant that all power emanates from the people, and the political system will be accountable and responsible only to the people of the country. That is the sovereign will of the people of the country. In synthetic chemicals, the court has the opportunity to deal with this sovereign power in a different context. And the court said the sovereign power is plenary and inherent in every sovereign state to do all things which promote the health, peace, education, and good order of the people. This power of sovereignty however, subject to constitutional limitations. And the constitutional limitations, one has to understand, we the people have given this constitution. It's interpreted by the Supreme Court. The Supreme Court is the final arbiter. That's a different power of judicial review. But the political system, the political steps, all are accountable to the citizen, the will of the public, the sovereign will. And if any act is done, that has to be within the boundary of constitutional limitations. Now, let's focus on socialism. See, there are so many judgments on socialism, but I will only refer to one. In Minerva Mills, while talking about the preamble is the edifice of the Constitution, it talks about socialism. The socialism is meant to crystallize a socialistic state, securing to its people socio-economic justice by interplay of fundamental rights and directive principles. That is why when the court tests the constitutionality of a legislation or a provision of a legislation, it also applies a test. If it doesn't violate the fundamental rights, that's fine. Does it meet? Supposing an argument is conversed on some other ground, some other constitutional provision, the court poses a question whether does the provision in the legislation meets the principles enshrined under Chapter 4, the directive principles of state policy. So that are the objectives they're supposed to achieve. Now let's come to the conception of secular. It is not defined anywhere, and it's better, as I'm going to quote a passage, that it has been left oppositely, being not defined. When the word secular does not mean that the country, the state, is an anti-religious state or atheistic state. It fundamentally means the state has no religion. Bomai case, while talking about secularism, the court said, I quote this para, the concept of secularism is very much embedded in our constitutional philosophy. The term secular has advisedly not been defined, presumably because it is a very elastic term, not capable of precise definition, perhaps best left undefined. By this amendment, what was implicit was made explicit. The preamble itself spoke of liberty of thought, expression, belief, faith, and worship. This is where they were dealing with the 42nd Amendment, whereby the word secular was introduced and incorporated in the preamble. The philosophy was always there. It was there in the preamble. That's what the court said. It's a beautiful list arose in 96 that pertain to intercaste marriage in Balsama Paul. The court ruled that intercaste marriages is an important social institution through which secularism would find its fruitful and solid base for an egalitarian social order under the Constitution. It's because secularism is the basic feature of the Constitution and a guiding principle of state policy. Such kind of institutions make the country look forward, and it really establishes a society which the Constitution has endeavored to establish. What do the words democratic and republic mean? Both the words are to be read together in a holistic manner. The Constitution of India has established a form of government which derives its authority from the people. People have the right to elect a government and also to unseat a government. And that is why a little man's vote matters. That's a beautiful phrase from Winston Churchill. There is a beautiful litigation that traveled to Apex Court in the year 1993 in Portugal, Archipelago. And Archipelago, the court said, quite interesting, democracy is a multifaceted system. It refers to the political participation of the people in running the administration of the government. It describes the state of affairs and rule of law under which every citizen has been assured the right to equal participation in the body politic. And that is what democracy stands for. You cannot have any other form of government. Now we come to the nicest part, which is very close to all of you, the professors and the students. Justice. What does justice mean? It's a natural concept. It's recognized by the constitutions. Further enumerated in various statutes. Justice refers to abolition of inequalities from the society. Social justice. Political justice means extinction of unreasonable distinction in political matters of the state. Economic justice conveys that each person is entitled to equal wage or equal work and further he must have the opportunity. While talking about justice, in Venice Public Education Society, the court said, I read this para, quote, justice in its connotative expanse engulfs the liberalism of an ocean, the magnanimity of the sun, the sternness of the mountain, the simplicity of a saint, the austerity of a Spartan, and the humility of a river. The concept of justice is to remain embedded in spite of adversities. It should remain unshaken, unterrified, unperturbed, and loyal to the rule of law. Unquote. This is the essence of justice, and I understand it this way and no other way. Now, let's see the other words, liberty and fraternity. Liberty talks of thought, belief, expression, faith, worship, and they are essential to an individual as well to a nation. Liberty means right to choose, right to express a choice, and there should not be an impediment unless it is constitutionally permissible. Liberty is not absolute. Freedom is not absolute. But any fettered put must be absolutely constitutionally valid. Despite this non-absoluteness, what is liberty? It has been said by a great thinker. Please listen to these lines carefully. What this great thinker talks about the liberty or freedom. And quote, like bone to the human body and the axle to the quill and the song to a bird and air to the wing, thus is the liberty, the essence of life, unquote. How more purposefully and poetically you can describe this magnificent concept called liberty. And coming to fraternity, fraternity comes emphasizing on the dignity, brotherhood. There can be dissent, there can be discordance, there can be difference of opinion, but there cannot be abuse. In fact, Dr. B.R. Ambedkar had said, without fraternity, equality, and liberty, we're no deeper than coats of a pen. Can we better it? We respect it. Now, when I talk about equality, as I have said, equality has been treated as a goal. Equality has been treated as an achievement, that the people must be raised, the marginalized and deprived must be treated equality. The formal equality is there, but equality has to be actualized. And that is what the courts have tried in many adjustments whenever the occasion had arisen. You see, there is a concept. Supposing there are two sticks, one is a big one, the other one is a small one. Somebody asks you, can you make them equal? You say, sure. Then you cut the big one and make them equal. This is not equalization. This is Christian justice. But a man who is affirmative, who is creative, who is thinking, who is human, he will search for another small stick and make the small stick longer. This is actualization of equality. You cannot remain alien to the vision of realistic framework of our compassionate constitution. One has to understand the intrinsic meaning and appreciate the living blood cells in order to march ahead with the changing time. I said this recently while explaining the meaning of the concept of transformative constitution. The apex court said that it has its kernel a place promise at first to transform the Indian society so as to embrace therein the letter and spirit, the ideals of justice, liberty, equality, fraternity as set out in the preamble to our constitution. These are the lines I'm quoting from 𝐒𝐂𝐑𝐈𝐁𝐄 Singh, where the court dealt with the rights of LGBT community. In conclusion, my dear students, I would like to suggest, and I would like to say also with sincerity, with all the humility at my command, I'm sure all of you, each one of you, shall take a place today to remain a loyalist to the noble ideology enshrined in the preamble to the Constitution. Before I part, I must express my thanks to the organizers of the Lloyd College, that institution which has established itself to engage the students in this kind of activities in this difficult times. They really deserve congratulations, and I, without any innovation or reservation, congratulate all of you. Thank you. Thank you very much.
Your Lordship, with your permission, can we take few questions?
What is the question?
Yes, sir. So there is one question from Mr. 𝐒𝐂𝐁𝐄. His question is, in what way preamble can be interpreted in the backdrop of insufficient number of judges to carry out proceedings which have resulted in denial of timely justice, amounting to the perpetuation of injustice, and denial of justice is antithetical to the concept of any civilized society. What is your opinion on that, sir? Is the denial of justice not the violation
No,
of
you see,
preamble of
let's
the
put it
Constitution?
this way. Access to justice is a fundamental right. And access to justice can be actualized, can be realized when there is a proper infrastructure. Infrastructure does not mean only buildings, it also means judges. That is why in the Supreme Court, in Bismone case and other cases, have directed the state governments to fill up the posts of the subordinate judiciary. And as far as the high courts are concerned, efforts are being made, and I'm aware of it, to fill up the post. And preamble, when it talks about justice, definitely and indubitably justice includes access to justice. And I have told justice is a noun, but it has to be converted to a verb. And and when it is converted to a verb, you really work on it, and that working on it is access to justice. And therefore, there can be no speck of doubt the preamble can be placed reliance upon.
Thank you, sir. Is there any other question? If anybody wants to ask any question related to preamble. So there is one more question from Mr. Vimal Kumar, whether preamble is inclusive or exhaustive.
I have already told the many theories by which the judges have understood and appreciated the preamble. They say, I told there is a constant thread theory, which Keshavananda Bharati says, because they establish, connect with each article. Let's not apply this doctrine as exhaustive or inclusive. That is meant for, it is a holistic reading. It introduces and it actually, where you will see the face of the preamble throughout the chapters 3 and 4 and other relevant articles. Wherever democracy occurs, preamble will come. Wherever justice occurs, preamble will come. Wherever the control comes, the concept of constitutional control, then also the preamble will come.
Thank you, sir. So, with your permission, can we take question on CAA and NRC?
They are all sub judice.
Yes. So there is one question. So there is one question. What is the relationship between we, the people of India, and the Constitution?
It starts with the people of India. If you have read some judgments, you will find the Supreme Court has says, and I have cited, referred to some, the entire power rests with the will of the people. The concept of constitutional governance in a democratic body politic rests on the desire of the people. No legitimate government can ignore the will of the people. And the citizenry composed of people, and the citizenry as a whole is empowered to topple a government, choose a government. So there is a, how can, that is why and they are governed by the constitution, and that is why there is an article, a beautiful one, a constitutional citizen. Everyone is controlled, governed, and administered by the principles of the Constitution. There cannot be a scintilla of doubt somebody is alien to the Constitution of India.
Sir, there is one question from Mr. Anurag Chandra. He's asking that he has asked in a different way. Let me rephrase it. He is asking when already in the case of Keshavananda Bharati in the year 1973, it was declared that secularism is part of basic structure and it is part of our constitution. Then what was the requirement to insert the word secularism in our preamble?
That was the wisdom of the, what did you say? What was the necessity to?
Insert the word, a specific word secular by 42nd
Amendment. That has been explained in Beaumont's case, that secularism was running throughout the constitution, and there was a thread in the constitutional philosophy relating to the constitution. That apart, the learned judges refer to the preamble and say that the preamble itself proclaims that the liberty of thought, expression, belief, and worship. So it's a secular content. Now it has been further crystallized by or further added by putting the word secular. Nothing wrong with that. So what was the necessity? We don't go to the necessity. We go to the legality. A student of law has to understand the legality, the jurisprudential concept, not the necessity in this way. What was the necessity? The necessity was the felt desire of the parliament. Well, we have to see a lawyer or a judge whether the parliament has acted within the constitutional limitations. Had the parliament had acted within the constitutional limitation by adding the word secular by amendment.
So just one more question, uh, because so many persons have asked question on the same thing. That can it be said that nowadays the words that are there in preamble can be removed through constitutional amendment, or the amendment could be done only in positive way, that is to include something?
You see, the preamble has been given the status of basic structure by Indra Sani judgment.
Yes.
If you can amend, it's a part of the constitution. You amend the constitution, but don't touch the basic structure. That's all right. Am I clear to you? How do you it's a part of the constitution. You can amend the constitution, like Article 15 has been amended, Article 16 has been amended, and their constitutional validity has been upheld. They relate to fundamental rights. But that is a content theory. In Nagraj, the Supreme Court says that the constitutional identity, the constitutional personality cannot be amended. But if amended, the change occurs. But the identity should not change, but there is a progression of that identity. There is no problem. There is no difficulty. There is no impediment.
Right. Sir, just one last question. What is, in your opinion, sir, in present day, considering the present government or the present country situation, is there any other fundamental value that should be inserted in any word in the preamble, or that should be mentioned in our preamble? Something extra that needs to be inserted?
I think the preamble is so well drafted. I, I don't think that any further word is to be added.
Okay, sir. Thank you.